Discovery in any litigation is the process of requesting information so that we can gather all of the facts surrounding property, the children. It's a formal process where discovery requests are sent to the other side. Typically, you only have 30 days to answer those, so it's something that you need to get on right away. And you need to be working as a partner with your attorney in this process. The attorney is the expert on the law, but you are the expert on your case. You should know what assets are out there, what debts are out there, and you certainly should know your children better than your attorney does. So it's a process that you must be very involved with in order for it to be effective. Typically in discovery, we get 3 different requests, which is a request for disclosures, and those are standard questions on every case. Usually, for my clients, the information I need from them is witness information. Then there is a request for interrogatories. These are actually answered under oath, and they're very similar to questions that you would be asked on the stand. You want to make sure that you give full and complete answers, and you really devote some time to this, and make sure to fact check anything that you put on that, as it will be under oath, and you can be held in contempt if you lie. The third one is request for production. This is the one that usually takes the most time because it is asking you for documents. And that's going to be documents as far back as you can get them on bank statements, credit card statements, any information on your assets, any information on your debts. And if there's children involved, you're looking at school records, doctor records, any kind of information affecting the children. So this can be time consuming, and 30 days goes really fast. So you want to make sure that you start gathering that process early in the case, even before requests are made. So when you're responding to discovery requests that are sent by the other side, you should give 100% accurate, full responses, because then your attorney will be taking those responses and putting them in a proper format. But your attorney needs to know the information as you would state it. This helps them prepare if it goes to trial. There are many objections that an attorney can make. And so just because you answer the question and you believe it's harmful to you, trust your attorney that they're going to put that in the best light for you. Sometimes we have to deal with bad facts. So don't try to hide them. Make sure that they're out there. That's the most important thing that I can tell any of my clients, is make sure I know everything, the good, the bad, the ugly, because I can prepare for those. Same with discovery. If you hide something or you don't give it to your attorney, and later it's something that's really important that you want to use at trial, you won't be able to use that information because it wasn't ever supplied to the other side. So make sure that you give everything and that you actually put time and effort into responding to those requests. Discovery is a very important part of the courtroom process, especially interrogatories, because those are said under oath. And it's not uncommon for an answer to be given in an interrogatory, and then when that same person is on the stand, they say something completely opposite. And you would be able to use the information that you obtain in interrogatories as what we call impeachment, which would show that they're not being honest. Either they were dishonest in their answers to interrogatories, or they're being dishonest on the stand. Either way, the credibility with the judge or the jury is lost at that point. So that's an important way that we can use it. Also know that any documents that weren't subject to an objection that was made and were not produced to the other side, that those can't be used in court. Our rules say that if we don't produce it in discovery and there wasn't a legitimate objection to producing it, that then we cannot use that information. And sometimes that's some of the most important information that needs to come out in court. So there's also, not responding properly to discovery could lead to a motion to compel. And that's going to be a court action where the other side is asking the court to sanction you or to fine you for not properly answering discovery. So it could really harm your case to not fully and accurately respond. And that's some ways that we can use it against the other side in court as well. If you have any questions about the discovery process, or you've been served with discovery and you're trying to go through this yourself, just reach out to us at the Boswell Law Firm. We're here to help.